I will be lecturing today on closing argument, which is lecture 9.1 in your curriculum materials which you have received. Closing argument is the pinnacle, the high point of the jury trial. It has been called a keystone. A keystone, of course, is a ключевой камень. A keystone is an architectural feature in a building that holds or connects two pillars. So, for example, if we have a pillar of stones in a building, a pillar on one side, and on the other side we also have a pillar or a column of stones. This is let's say this is a doorway or an archway in a building. At the top there will be stonework and there will be one stone at the top that is called the keystone. The keystone holds the arch together, and then of course we might have bricks or other stone built around. The keystone is designed to hold a great weight. The keystone connects the two arches of the doorway, and it is designed and crafted very carefully. It is the most precise of all the building stones. That is true as well with the closing argument. The closing argument must bring together and support the entire case. If this column is the law and this column is the facts, for example, the keystone connects the law and the facts. And so I want you to think of the closing argument in terms of a keystone. The other way that I want you to look at closing argument is in terms of a picture, a painting, a visual of some kind. In the closing argument, you are creating a story, a theory, and a theme that the jury will follow in trying to understand the case. Presenting a good closing argument is much like writing a novel or writing a short story. We as advocates must become, as it were, the Lev Tolstoy, the Ernest Hemingway, the Alexander Pushkin of advocacy. We're creating a story, an image, a visual. You want your jury to see and hear and feel the facts. You don't just want to tell them the dry facts of the case. You want to create a picture, something that is memorable, something that they'll take with them. I think it's appropriate that I am giving this lecture here in my own courtroom. This is my courtroom. We have here the prosecutor's table. Over here we have the defense table. This is the podium where the attorneys stand to address the court. I sit over here on the bench. Here is the jury box here where the jury is addressed during jury trials. The witness sits here, the clerk sits here, I have my bailiff or security sit here, and then of course the spectators sit back here in the courtroom. I think it's appropriate to give this lecture on closing argument here in my court where many, many closing arguments are given. I handle approximately 10,000 cases a year in this court. Most of them are minor criminal matters or traffic matters. However, we do a lot of jury trials. For example, we have conducted 3 jury trials in this room in the last 6 weeks. So the jury trial is the pinnacle or high point of the closing argument is the high point of the jury trial. What I'd like to have you do now is to refer back in your materials to the fire truck case. This is contained on pages 283, 283, and page 284 of your materials. What I'd like to do is read the excerpts. In fact, let me get my whiteboard over here so I can write those page numbers down for you. Again, this is pages 283 page 283 and 284 of your materials. Let me read you this excerpt. Assume that you are an attorney in a mock trial, representing a plaintiff who was injured in an automobile accident. Your client knows only that when traffic slowed to allow a fire truck to pass, her car was hit from behind by another car. You are suing the driver of that automobile for his negligence in failing to take due care while operating his car. You now must determine why the other driver failed to slow and stop with the rest of the traffic. Then, if you'll look down towards the bottom of page 284, it says, assume that your case file shows that at 8:20 in the morning, the defendant was driving south on Craycroft Road on his way to work downtown. Rush hour was in full swing, and he had an important meeting that was to begin at 8:30 a.m. sharp. You also learned that after he parked his car near work, the defendant would have to walk 2 more blocks to get to his office. From the point at which the accident occurred, it would likely take the defendant another 20 to 35 minutes to drive to his parking lot, park, and then walk to his office. Furthermore, your case file reveals that immediately following the collision, the defendant used a cellular phone to call his office. Then if you'll turn to page 284, actually those 2 excerpts were on page 283. On page 284, it says, let us assume in this example that the plaintiff is certain that the fire truck was flashing its lights but not sounding its siren or bell. Remember that there are other details that you have previously read about the fire truck case. For example, the fact that the plaintiff went camping and slept on the ground for 4 days and so on. So what I want you to have you do is to study those facts. If you need to turn the video off and study those, why don't you do that now? And we are going to be referring to these facts numerous times throughout the lecture today on closing argument. Now, what I'd like to do is to discuss